Right, good morning everyone, and welcome to the Contentious Trusts breakout. The topic that we're going to be looking at today is the use of commercial and insolvency remedies in trust litigation. And before I introduce the topic, I'm going to introduce our panel. So first of all, we're going to be hearing from me, but then we're going to be hearing from Jacob Ward, who's a senior associate at Macfarlanes here in London, where he specialises in private client disputes, fraud and insolvency. And with that background, it won't come as a surprise to learn that he has a particular interest in Russia. We're then going to hear from Poppy Rimington-Pounder, who is one of Radcliffe Chambers' rising stars. And as well as a busy practice here in the UK, she's also been called in BVI, where she's been working on a large commercial dispute recently. Then we're going to hear from Andreas Kistler, who really doesn't need any introduction at all. He's a partner at Carey, Olsen in Jersey, and as we all know, he's one of the top Jersey advocates in the trust litigation sphere. So I'm Josh Lewison, and I'm also at Radcliffe Chambers, where I do insolvency and trust litigation, sometimes at the same time, both onshore and offshore. And our topic today is about the growing trend for using commercial and insolvency remedies in trust disputes. And this is really exemplified in the evolution of trust disputes over the last 5 or 10 years. So that 10 years ago this year was the starting point of the Crociani litigation. And that's a really good example of how trust litigation used to be. So that as I'm sure everyone knows by now, it's a dispute between Madame Crociani and her daughter, Christiana. And it all started when Christiana was removed as the shareholder of a company in the Netherlands Antilles without her knowledge or consent. And she started off by getting her lawyers to send a letter before action and got a pre-judgment attachment on the shares. The next year, 2012, there was a pre-action letter in Jersey, and then the main litigation started. But between the proceedings in the Netherlands Antilles and proceedings in Jersey, the trustee had purported to retire in favour of a Mauritian trustee, and the assets had been dispersed around the world. Nowadays, I think we're much more likely to start with injunctive relief, so that about 3 years ago, I was involved in a case called Volpe, which was in the Bahamas. The brief background to that is that the settlor had put his business empire into a trust for the benefit of himself, his wife, and his children. He divorced his wife, fell out with his sons, and the trustee appointed all the assets to him or to entities connected with him. I was part of the team acting for the trustee, and the first that we knew about the proceedings was when we were actually served with an injunction and a writ and a statement of case, transcript of the hearing, affidavits, exhibits, great wardrobe of papers. And this is a trend that seems to have spread throughout the trust litigation world, so that there's a case I'm involved in at the moment where, again, first we heard of it was we were served with the proceedings and a draft application for an injunction, and we were asked to give undertakings to avoid having to go to court on that. The injunctive relief that we particularly see in trust disputes is a proprietary injunction. So it's not the traditional moraver. The difference between the two, the key difference between the two, is that a moraver injunction seeks to prevent the defendant from dissipating their own assets, whereas a proprietary injunction prevents dissipation of trust assets. It's easier to get one than it is to get a moraver because you don't have to show there's a risk of dissipation. It also means that the assets are frozen to a much larger degree, because normally the respondent can't spend the disputed fund on their ordinary course of business or their reasonable living expenses, and they also can't normally spend the fund on legal fees. And then disclosure is also much more readily granted off the back of a proprietary injunction than off the back of moraver. So that's something that's already happened, and in this session we are hoping to explore some of the remedies that can usefully help us to get the best outcome for our clients when we're having disputes over trusts. And the starting point, of course, is the pre-action stage, which is the crucial bit. And so it's over to Jacob to tell us about pre-action evidence gathering.
Thank you very much, Josh. What I wanted to share today in a fairly brief session are two interesting alternative approaches to disclosure, which I think are possibly somewhat underused by private client practitioners and private client litigators. They're provisions that may be known to many of you. They're widely used in fraud or white-collar crime litigation. For those of you who are litigators, I hope they're interesting tools to consider using if you don't already. For those of you who are non-contentious lawyers, this may just be a little bit of a scare story about exactly how much information can be obtained and something to advise and warn your clients about. The two specific tools that I'd like to talk about are Section 236 of the English Insolvency Act 1986, which is a power for insolvency practitioners to compel disclosure, and discovery in the United States through what's called Section 1782 after provision 28 USC 1782 of the US Code. Given the time available, I'm not going to try to get into an enormous degree of detail. If anyone has questions afterwards and we don't have time to deal with them today, please do feel free to reach out and get in touch, and I'd be delighted to talk about them. Turning first to Section 236, many of you will already be familiar with the section. For those of you who aren't, the provisions of Section 236 are that the court may summon to appear before it any officer of the company, a person known or suspected to have in his possession any property of a company, a person supposed to be indebted to the company, or any person whom the court thinks capable of giving information concerning, broadly speaking, the business of the company. It applies to any company, any English company going through an insolvency process. The court may also require any person falling within those extremely broad categories to provide any documents or records in their possession or control relating to the company or to its business or to its dealings or to its affairs or to its property. And so the first point, just to pause and note, is that in comparison with the sort of disclosure that we might normally be familiar with through ordinary pre-action disclosure under the CPR, this is extraordinarily broad. And in trying to persuade you that this has real advantages for persons acting in trust and probate litigation, I could just stop there. I could point to the enormous breadth of the section, the ability to bring persons in to be cross-examined in what has been described as exceptionally hostile cross-examination. It's also worth noting that the power reaches beyond the jurisdiction of the English courts, and persons overseas can be summoned. But the real advantage, I would suggest, is not in the scope of the section, but in its purpose. And the House of Lords has said that the purpose of Section 236 is to allow an insolvency practitioner to discover the truth of the circumstances in connection with the affairs of the insolvent company, and to allow that insolvency practitioner to gather in the assets of the company and to do so with as much ease and as little expense as possible. That is practically an invitation for an insolvency practitioner to embark on a fishing expedition. Of course, it's not an uncontrolled power. Of course, it remains discretionary. It must be exercised for a proper purpose. But what the courts and the legislators are recognizing here is that an insolvency practitioner coming into an insolvent company, or a company going through an insolvency process, may well have no historic knowledge of the company, may have been left with very few records. The officers of the company, particularly if they are wrongdoers, may well be long gone and outside the reach of the court. And so the insolvency practitioner has allowed this much wider power than most litigants would enjoy in order to try to bring in the information that they need in order to put right anything that's gone wrong. This is a section that we have very recent experience of using successfully in a situation that will be well known to everyone here, I'm sure, that funds have been paid over to a trustee to be held on trust. The funds had then not seemingly been used properly, something had gone wrong. The trustee had gone, the records were gone, the beneficiaries, as is often the case, had no real visibility behind the curtain as to what the trustee was doing, because trustee decisions are not normally shared with their beneficiaries. And there was probably a route to get to that information eventually, and after a lot of time and expense, using traditional CPR disclosure. But because the trust fund included UK companies, This alternative route is available of putting those companies into an insolvency process, which makes sense where something has gone so badly wrong, which then allows the insolvency practitioner to make use of the very wide power under Section 236 to obtain documents, get to the bottom of what's done, and we hope eventually bring proceedings to try to reconstitute the assets that seem to have gone missing. And that, I would suggest, is a situation that will be very familiar to many of you, and a tool that may well be useful. My second example of an unusual tool that possibly could be used more frequently in private client litigation is what's called Section 1782 discovery after the provision of the US Code. And what that provision says is that the district court of the district in which a person resides in the United States or is found, and that's a point worth noting, may order that person to give testimony or a statement or to produce a document or other thing for use in proceedings in a foreign or international tribunal upon the application of an interested person. And so there are three requirements: a person who resides or is found in a district in the US, documents or testimony required for proceedings outside the United States, and an application by an interested person. And if you are a party to the foreign proceedings, you will be an interested person. The power is incredibly broad, and it's something of an exercise for someone familiar with English or offshore rules of disclosure. It's a bit of an exercise of trying to think of what the restrictions would be and then finding that they don't apply. So the standard is that the information sought, generally speaking, has some relevance. The burden on the applicant has been held to be de minimis. The documents that are sought don't need to be admissible, and the documents that are sought don't need to be discoverable through the foreign tribunal. And in fact, it will be helpful if you can say to the US courts that there's no way of getting these documents because they're not available under the rules of the foreign tribunal. That would be a reason that the US courts assistance is required. And traditionally, this has been interest primarily to persons who reside or do business in the United States. Of course, that's still the case. And it is still the case that the US operates what is referred to as its tag jurisdiction, that a person can be treated as being in the United States for these purposes, even if they are just passing through. But where this is really exciting at the moment, I would suggest, is that the world is changing in a way that is shifting information to the United States and into the possession of companies in the United States that are within the jurisdiction of the section. We'll all be familiar with the fact that many people, many companies, whether they know it or don't know it, are storing an enormous amount of information about themselves on servers that they probably don't know unless they've gone through some sort of risk management process. They probably don't know where they are. Many of those companies, until this year, have stored information about British users in the European Union, and particularly in Ireland. Post-Brexit, that information is potentially moving to the United States. Google, for example, have announced this year that because of concerns about whether information will be able to be transmitted freely in future between the EU and Britain, that they're going to move British users' data from their EU servers to their US servers, where it will be under the control of US companies amenable to Section 1782. So an enormous expansion in the information about British persons that will be within the reach of this section. So what can you get? Well, I should be clear straight away about what you can't get. You can't get stored communications, so you're not going to be able to get someone's actual emails unless that person consents. But what you can get is usage data, subscriber data, the information people give when they sign up, IP addresses, and therefore their approximate locations when they were using the service. And potentially, although I believe there's split authority on this, recipients and senders of emails, even if you can't get the content of the emails themselves. And we've been involved in an example for a case, for example, where this was used to try to identify the mystery user of an email account who was preferring not to identify themselves. And what I would just suggest is that even without the content of communications, that is an absolute wealth of information, and information that is particularly relevant to private client practitioners. So just imagine, for example, a dispute over the domicile of a person. where rather than trying to extrapolate from travel records, you had their IP address and therefore their location that they accessed their emails or their Facebook or whatever it might be each day in the relevant period. Wouldn't that just be absolutely fantastic? With that, I'm going to stop there, leave you with a couple of ideas and hand over to Poppy.
Thank you, Jacob. Yes, my focus today is going to be on freestanding freezing injunctions in the BVI. When we say freestanding, what we mean is freezing injunctions in support of foreign proceedings. And I would say that such relief is really important for private client practitioners because in any sort of breach of trust, breach of express trust, breach of fiduciary duty, or straight fraud claim, it's important to try and preserve assets for enforcement of any judgment. And assets often in such claims are found in the possession of companies incorporated in the BVI. I'll be doing a bit of a whistle-stop tour of freestanding freezing injunctions, looking at the position in the BVI prior to 2010. Then in 2010, there was this case, the Black Swan Investment and Harvest BU Limited, which you will all be familiar with, I'm sure. But then the 2020 case of Broad Idea and Convoy Collateral, where it was held that Black Swan was wrongly decided and no such jurisdiction existed. And finally, moving on to the new Section 24A of the Eastern Caribbean Supreme Court Virgin Islands Act. So to start first with the position in the BVI prior to Black Swan, the interim relief position is governed by Section 24 of the ECSC Virgin Islands Act, which provides that an injunction may be granted by an interlocutory order of the High Court or of a judge thereof in all cases in which it appears to the court or judge to be just or convenient that the order should be made. So there's nothing explicit in that provision about relief in aid of foreign proceedings. And indeed, it was held at common law by the House of Lords case, the Siskina, in 1979, that it wasn't possible. In that case, the substantive proceedings were taking place in Cyprus, but the claimants then tried to seek freezing relief in England and Wales. The House of Lords held that a Moreover injunction needed to have a pre-existing cause of action amenable to the jurisdiction of the court. And so the Moreover relief could not just stand on its own. The position at the common law was subsequently ameliorated in the UK by Section 25 of the Civil Jurisdiction and Judgments Act, which came to force for the UK from January 1987, which provided that you can get interim relief in the absence of substantive proceedings in the UK if proceedings have been commenced or are about to be commenced or are to be commenced in a Hague Convention state other than the UK. So as long as your foreign proceedings were taking place in a Hague Convention state, the Siskina became redundant. But this was not the case for common law jurisdictions. And in fact, there's a Hong Kong Privy Council case, Mercedes-Benz and Lyduk, in 1995, which addressed this, this issue. The substantive proceedings in that case were taking place in Monaco, but a freezing injunction was sought in Hong Kong. The majority actually decided this case on the basis of the court's territorial jurisdiction and held that the court did not have the power to order service out of the jurisdiction of the Moreover proceedings. It did not substantively address what it called the subject matter jurisdiction question, or arguably didn't substantively address it, and by subject matter jurisdiction question, what I mean is whether the court actually had the power to grant a Moreover injunction in aid of foreign proceedings. The majority, however, did express doubts that it would not be permissible to serve an originating process claiming only Moreover relief, even against a defendant present within the jurisdiction. There was, however, this dissenting judgment from Lord Nichols, which has been much discussed since. And that in that judgment, Lord Nichols considered the question of the territorial jurisdictions about whether service out was possible. But he first and foremost considered the question of the subject matter jurisdiction. And he did conclude that the court had jurisdiction in both senses. I couldn't possibly summarize the entire of Lord Nichols' judgment now, but it is very interesting and worth a read. But some of his points that I think are particularly persuasive is that, well, he said, first of all, it would be just and convenient to grant such a relief. And he focused in particular on the fact that this injunction, a Morava injunction, is in respect of a prospective enforcement process in that jurisdiction when a judgment was entered and came to be enforced, recognised and enforced. And the defendant should not be permitted to, as he said, steal a march on the enforcement process. He also thought that Morava injunctions were fundamentally different to normal interlocutory injunctions, which are merely ancillary to a cause of action. And that was something that the majority reasoning had relied on. So this was the case for the BVI as a common law jurisdiction for many years, until the case of Black Swan and the judgment of Mr. Justice Bannister in that case in March 2010. In that case, the substantive proceedings were in South Africa, but Black Swan had applied to the BVI court for freezing injunctions in aid of the South African proceedings in respect of two BVI companies, which they said were under the control or the ownership of the South African defendant. Mr. Justice Bannister held that the BVI courts did have the jurisdiction to grant the freezing orders against the non-cause of action defendants who were located in the BVI in support of the foreign proceedings. His reasoning was that he thought there was a lacuna in the authorities, namely this question about whether a freezing order should be granted in aid of foreign proceedings against a defendant who is subject to the court's jurisdiction. As I said, the majority in Mercedes-Benz had expressed doubts about this, but hadn't really explicitly necessarily decided the issue. And what he did instead, Mr. Justice Bannister, was he adopted what he described as the compelling reasoning of Lord Nichols in his dissenting judgment in Mercedes-Benz. The judge also referred to the policy reasons about why offshore financial centres should be in a position to grant such orders where necessary. And I think that's really important because this was a huge development in the BVI. BVI is a massive offshore financial jurisdiction. It's a highly attractive place for individuals and corporate entities to hold their assets, given the incredibly favourable tax position, and also historically at least, company ownership has always been relatively opaque. So we frequently see BVI vehicles appear as holding and receiving entities in asset recovery litigation. I've been working on a case recently where a number of offshore vehicles were used to receive assets in breach of fiduciary duty, and the majority of them were BVI entities. So this was what I think was a really important development for the BVI as an offshore financial centre. And these injunctions were granted in the BVI courts for the next 10 years as sort of standard relief until the judgment of the Court of Appeal in Broad Idea International and Convoy Collateral in May last year. In that case, Convoy had commenced substantive proceedings in Hong Kong against Dr. Cho, but then had applied to the BVI Commercial Court for freezing injunctions against Dr. Cho, but also Broad Idea, which was a BVI company. The Court of Appeal held in that case that the BVI courts were in fact bound by the majority judgment in Mercedes-Benz and Lyduk, and held that Black Swan was wrongly decided because they said it wasn't open to the judge to adopt the dissenting judgment of Lord Nichols in that case. And they held that in the absence of a legislative enactment, the BVI courts did not have jurisdiction to grant these freestanding injunctions in support of foreign proceedings. Now, the permission was granted to appeal to the Privy Council, and that appeal was heard in February this year. And we are now awaiting judgment, which I expect will be handed down later in the year. But the question is, well, where did that leave everyone in the meantime? It threw into jeopardy a number of Black Swans that were injunctions that were previously granted. The court in Broad Idea did confirm the continued existence of the Chabra jurisdiction. So if a claimant can establish a good arguable case that assets apparently owned by a third party are in fact beneficially owned by the defendant against whom there is a cause of action, then a claimant can obtain a freezing injunction against that third party. So it was useful they did confirm that jurisdiction. And that offered a potential route for some litigating parties. So I had a case last year where foreign proceedings had been commenced, and actually judgment had been obtained, but the freezing injunctions had been originally obtained on the black swan basis. And after Broad Idea, there was this danger that the injunctions would be discharged. And so what we had to do was really quickly issue substantive proceedings for recognition and enforcement of the foreign judgment. And we sought injunctive relief on the basis of the Chabra jurisdiction. But the key point is that the court has to be sized of the substantive proceedings. And there are obviously cases, such as Broad Idea, where it's not possible to have a freezing injunction on the basis of Chabra jurisdiction because you simply can't issue substantive proceedings there. I mean, if you haven't already got your judgment in your foreign proceedings, then you can't issue proceedings for recognition and enforcement. And that could lead to the result that enforcement will be rendered completely redundant because you haven't in the meantime got your freezing relief, and so the assets have been dissipated in the meantime. So thankfully, the BVI legislature acted remarkably quickly and passed the Eastern Caribbean Supreme Court Virgin Islands Amendment Act 2020, which came into operation on the 7th of January this year. And the new section 24A of the ECSE Virgin Islands Act provides that the High Court or a judge thereof may grant interim relief where proceedings have been or are about to be commenced in a foreign jurisdiction. And we've also helpfully already had guidance from the Commercial Court on this provision. There was a judgment called X in a TBI company earlier this year from Mr. Justice Wallbank on the 30th of March. And he held that given the similarity to Section 25 of the UK Civil Jurisdiction and Judgments Act, the BVI court should also adopt the English court's approach. And he followed the Court of Appeal case of Refco Inc. and Eastern Trading Company. So just to sort of wrap up and see where that leaves us now, freezing relief in aid of foreign proceedings is available in the BVI on this legislative basis. And we've already had guidance from the courts on how they will approach such applications. And so the BVI continues to be a jurisdiction which readily enables effective asset recovery. And the only question really left now is be interesting to see what the Privy Council decides when judgment is handed down later this year. I'd say it would still be very relevant for other common law jurisdictions that haven't yet enacted legislation and would be bound by Mercedes-Benz. But I'm now going to finish there and pass over to Andreas.
Thank you, Poppy. So I'm going to comment on an attempt to obtain post-judgment relief against a Jersey trust earlier this year. But before I do that, I'm going to set the scene by reminding ourselves of a couple of Cayman authorities, which I'm sure a lot of the attendees will be familiar with. And the first was the judgment of the Privy Council in the Cayman Islands case of TMSF. And in that case, you'd had a judgment creditor who sought to enforce against the interests of a settlor in a Cayman discretionary trust. And on the particular facts of that case, the settlor had retained to himself the power to revoke the trust and also to vary the trust. And the consequence of the exercise of the power of revocation in particular would have been that the assets of the trust would revert to the settlor personally. So what the judgment creditor sought to do and was successful in doing was to have the court appoint a receiver over the settlor's power to revoke, the argument being that the settlor's power was so extensive as to be tantamount to ownership of the trust assets, and therefore that the power was itself property over which a receiver could be appointed. That was followed by the subsequent judgment of the Grand Court of the Cayman Islands in Y versus R. And there was an attempt by a judgment creditor to appoint a receiver over the interest of a discretionary beneficiary who didn't have a power of revocation. And the particular facts in that case showed that distributions from this particular trust had only ever been made to the judgment debtor, and that there was an established pattern of annual distributions to him, so that the creditor could say with some confidence that it's almost inevitable there's going to be further distributions made in favour of this judgment debtor. And they argued that once the trustee had exercised the discretion in that way, the property would then be held on fixed trust for the judgment debtor, and it would therefore be susceptible to attachment. The court declined to appoint a receiver on those facts, holding that the interest of the discretionary beneficiary was not tantamount to ownership and therefore could not be considered property, which was susceptible to a receivership. So that sets the scene for the Jersey case of Carey and Watson. And in that case, Carey was a judgment creditor of Eric Watson, and Watson was one of the discretionary beneficiaries of 3 Jersey trusts on conventional terms. He was also a default beneficiary at the end of the indefinite trust period. So the Carey sought to obtain payment of its judgment using the Jersey remedy of the arrêt entrement, an arrest. The same remedy or similar remedy exists in Guernsey under Guernsey law. And they sought to attach essentially Mr. Watson's interest under those discretionary trusts. The key fact about a Jersey remedy of an arrest is that it allows a judgment creditor to obtain an attachment against property belonging to the judgment debtor in the hands of a third party. And the cases have shown that it applies to tangible, movable property, but it also applies equally to intangible property, shows as an action, debts owed to the judgment debtor, and so on. And in those cases, the creditor can enforce directly against the third party and obtain the asset from them in discharge of the debtor's liability. The cases have also shown that an arrest can be made against future property, provided it can be identified with sufficient precision. So looking at trust law, it's clear that a beneficiary of a discretionary trust doesn't have a property interest in the trust assets themselves, unless the trustee exercises a discretion in the beneficiary's favour. Their right is to be considered from time to time by the trustee for benefit, and they can compel consideration. So Carey, wisely, I think, did not try and obtain direct enforcement against trust assets. What it sought to do instead was to enforce by attaching Mr. Watson's interest as a discretionary beneficiary. It accepted that if it was successful, it would not be in any better position than Mr. Watson was. So it could not force the trustee to make a distribution to Mr. Watson or to Carey directly. But what it sought to do was effectively to substitute itself for Mr. Watson as beneficiary until such time as Mr. Watson's debt was paid, so that it would have the ability to obtain disclosure of trust information and to compel the trustee to consider from time to time whether to make a distribution to it. So the question to determine whether this attachment was permissible was again whether Mr. Watson's right as discretionary beneficiary amounted to property. And what was perhaps different in this case was that the Trust Jersey law contains specific statutory provisions which provide that the interests of a beneficiary under a Jersey trust shall constitute movable property. And it also provides that subject to the terms of the trust, the beneficiary may deal with their interest under the trust. So they can assign it, they can transfer it, they can sell it, and so on. It's an open list of what they can do. But the court declined to order an arrest over Mr. Watson's interest. And its reasoning was that the beneficiary's rights aren't freestanding. They are defined by the terms of the trust themselves. And so the court had to analyse the nature of the discretionary trusts in this case. And it held on the facts that Mr. Watson's rights to be considered as discretionary beneficiary were personal to him under these trusts, and that they were not capable of transmission or assignment, whether that's voluntarily or involuntarily by way of the arrest. However, Mr. Watson was owed repayment of various loans that he had made to companies underlying the trusts, and those loans, the right to repayment of them, was his property, and those were successfully arrested by the judgment creditor, just not providing as much recovery as they obviously wanted from the trusts themselves. So as it stands, the Keir judgment is a clear impediment to creditors seeking to enforce against the interest of discretionary beneficiaries in Jersey, but it's perhaps not the last word, because as the court emphasises, it's a question of the terms of each particular trust in question. So had Mr. Watson been conferred a life interest in the income of the trust, then that more than likely would have been capable of arrest. And further, the court didn't consider, or at least the judgment doesn't record that it considered, whether Mr. Watson's potential future property in distributions that the trustee might resolve to make in his favour could be attached now on the basis that you could define them with sufficient precision. That's perhaps been left open for a future case to develop as well. So moving on from that, there have been a number of cases where the Jersey courts have considered various remedies of an insolvency type nature in the context of trusts, and one has been the remedy of receivership. So the court has ruled some time ago in the Mubarak case that that it has the ability to appoint receivers in a clear case where it's necessary to do so. It's an extraordinary remedy, but nevertheless one that the court has in its arsenal. And in the Mubarak case, it's well known, a divorce case where the husband had sought to evade his obligations under the family court's order. The Royal Court of Jersey had found that he had consented to the Jersey Trust to be varied to allow payments to be made to his wife in discharge of the family court's order. But the difficulty was that the trustee didn't have control of the trust assets, didn't particularly know where they were, and it couldn't recover them. So it commissioned a report from KPMG, which provided an outline of how that might be achieved. The trustee then said, well, we don't have experience in how to go about these sorts of asset recovery actions. We also don't have any funds available to us in the trusts, and so we don't feel well placed to do it. So the court, on the exceptional facts of that case, directed the appointment of KPMG as receivers. They appear to have been willing to pay themselves out of whatever recoveries they achieved from their appointment. More recently, in the Crociani case, last year, the court appointed a receiver over the promissory note held in the Grand Trust in circumstances where the former trustee of the Grand Trust, Appleby Mauritius, had been held liable to pay equitable compensation for the value of that promissory note. Appleby Mauritius paid that equitable compensation to court and was therefore effectively entitled to be subrogated to the trust's right to enforce the promissory note. The court appointed receivers to go ahead and seek to enforce the note and to pay the proceeds into court. And earlier this year, the court discharged the receivers upon the successful completion of their role. And then finally, of a more general insolvency nature, the case of the Z Trust will be well known, and of course it's actually being heard before the Privy Council this week. But it is a good example of how various insolvency remedies and regimes can be adapted to fit the situation where claims against trust assets exceed the value of the trust assets themselves. And of immediate interest is that over a number of judgments, the court considered it had the ability to appoint an insolvency practitioner to wind up a trust effectively in circumstances where that would be appropriate. But until last year, at least, it had resisted doing so in the particular circumstances of the Z2 and Z3 trusts on the basis that the trustee should do so, and it could potentially do so more efficiently and cheaply. However, in April last year, it finally relented and it did appoint a representative from Smith & Williamson to wind up the Z2 and the Z3 trusts. And it did so for reasons of conflict, for reasons of the complexity of the claims, and finally, because of the independence of that insolvency practitioner from any of the family members or persons involved with the Z2 and Z3 trusts. And it's interesting that the court achieved the appointment of that insolvency practitioner by directing the trustee that it shall appoint that person, essentially a delegation by the trustee of its powers. So the court expressly did not appoint Smith & Williamson as a receiver, because it was no part of its role to get in trust assets. So that's all I'm going to say in this short session. I'm happy to hand back to Josh.
Thanks, Andreas. Just in the last couple of minutes, I'm going to tell you a little bit about CPR Part 71. We don't normally look at the higher numbered parts of the civil procedure rules. And in fact, this used to be sort of a grubby procedure for examining judgment debtors. You would send a very junior barrister along to the county court to find out why someone hadn't paid their credit card bill. But now it's mainstream. It's used in the High Court all the time now. Essentially, it is the judgment creditor's opportunity to examine, which means cross-examine in this context, a judgment debtor. You're not confined to personal liabilities, so that where you've obtained proprietary relief, you can use it to locate assets. It's sort of the civil counterpart to Section 236 that Jacob told us about. But unlike Section 236, you're not limited by the idea that you can't gain an advantage in litigation, because litigation is over. It has some extraterritorial effects, so not limited to domestic debtors. The court already has jurisdiction over them. You're not limited to domestic assets either, so you can discover assets all around the world. You can get company officers. If they're outside the jurisdiction, then they're outside the scope of CPR Part 71. But if they do come into the jurisdiction, even just for a fleeting visit, then provided you can serve them in time, then you can examine them too. Again, as with Section 236, the cross-examination is not limited. It's been described as cross-examination of the severest kind, and you're not limited to determining any issues. So it's not about determining a dispute over whether someone has assets. It's purely interrogatory. So that sort of caps off this session. So we've heard from Jacob, who told us all about how to get the information before you've started proceedings. Poppy, who's told us about how to preserve assets while your proceedings are pending. Andreas, who's told us to get the assets in after you've won. And so it's for me to thank all three of them for participating in this panel, and to thank the attendees for attending. So thanks again to our panel, thanks to the attendees, and enjoy the rest of the day. Thanks very much.